The United States Constitution sets qualifications for United States senators. You must be at least 30 years old. You must have been a citizen for 9 years. You must live in the state you represent at the time of your election. What the Constitution does not set is a limit on how long you may serve. One senator served for more than 51 years, another for more than 47, another for more than 46. These are not anomalies. They are the natural result of a system in which incumbents enjoy structural advantages that the founders could not fully have anticipated, that the ballot box has repeatedly failed to correct, and that no state has the constitutional authority to fix on its own. In 1995, the Supreme Court settled the question of whether states could impose their own term limits on members of Congress. The answer was no. U.S. Term Limits versus Thornton, 514 United States 779, held 5-4 that the qualifications for Congress are set exclusively by the Constitution. A state cannot add to them. Only a constitutional amendment can impose term limits on the United States Senate. Tonight on Words with Wentz, I am going to make the case that one is needed, clearly, as my position, documented. I am going to present the counterargument fully, because it is serious and it deserves to be heard. And I am going to tell you exactly what a constitutional amendment would require and why the path, while difficult, is the only documented one available. This episode is part of the legislative accountability arc that began with EDU 45 and EDU 47. If you have not watched those episodes, the links are in the description. The documents are public. The position is mine. Let's go. To make the case for term limits honestly, I have to start with why the founders designed the Senate the way they did, because the argument for unlimited tenure is grounded in what Madison wrote, and it deserves to be engaged directly. Article 1, Section 3 of the Constitution established a Senate with 2 senators from each state serving 6-year terms. Senators are divided into 3 classes so that approximately 1/3 face election every 2 years. This staggered system ensures that the Senate never entirely turns over at once, providing continuity across election cycles. In Federalist No. 62, Madison argued that a second legislative chamber with longer terms would provide stability, protecting the nation from sudden shifts in public opinion that might drive the House to hasty or ill-considered action. In Federalist No. 63, he went further. The Senate must sometimes be capable of acting against temporary errors and delusions of the people, serving the long-term interests of the nation even when those interests are unpopular in the moment. These are serious arguments. Madison was not naive. He understood that democracy could produce bad outcomes when passions ran high. The Senate's design, longer terms, smaller size, greater institutional stability, was a deliberate check. But here is what Madison did not argue in Federalist 62 or 63, that senators should serve indefinitely. The stability he described is institutional. The Senate as a body should persist and provide continuity. That stability does not require the same individuals to hold power for 5 decades. Elsewhere in his writings, Madison acknowledged the principle of rotation in office, the idea deeply embedded in Republican theory that periodic change of leadership is itself a democratic virtue. The founders limited the presidency to 4-year terms. They limited themselves as delegates. The absence of a Senate term limit was a choice made in a specific historical context, not a declaration that unlimited tenure was the ideal. The argument for term limits is not primarily about any individual senator's performance. It is about a structural problem that the Congressional Research Service has documented. The advantages of incumbency compound over time in ways that make competitive elections increasingly difficult to achieve. Incumbent senators enjoy greater name recognition than challengers, built over years of constituent service, press coverage, and public visibility. They have established fundraising networks that challengers must build from scratch. They have constituent service operations that generate goodwill and loyalty regardless of their legislative record. Seniority creates an additional structural advantage. Longer-serving senators receive more influential committee assignments. Committee chairs control the legislative agenda in their areas. Which bills get hearings, which amendments get considered, which nominations move forward. That power generates more donor interest. More donor interest generates more resources. More resources generate more institutional power. The result is a feedback loop that the ballot box by itself has consistently failed to interrupt. Senate re-election rates have historically run between 80 and 90%, not because 80 to 90% of incumbent senators are doing an objectively superior job to every potential challenger, but because the structural advantages of incumbency make the competitive threshold so high that most challengers cannot overcome it. The Congressional Research Service documents that average Senate tenure has increased over time. The Senate is getting less competitive, not more. And the longer any individual senator serves, the more entrenched those structural advantages become. Elections alone have not solved this. The record shows it clearly. The counterargument to term limits is serious, and I am going to present it as its strongest advocates do, not as a straw man. Foreign policy, taxation, national defense, international trade, constitutional law, these are not subjects a senator masters in a 2-year orientation. They require years of accumulated knowledge, relationship building with foreign counterparts, familiarity with classified briefings, and experience navigating the specific procedural landscape of the Senate. A senator in their first term asking questions that a senator in their 5th term already knows the answers to is not a sign of democratic health. It is a sign of institutional inefficiency that has real consequences. The experience argument has a more pointed dimension. If senators are forced out by term limits, their institutional knowledge does not disappear. It transfers. It transfers to senior staff members who are not term limited and not elected. It transfers to lobbyists who have spent decades building relationships with those same staff members and now have no elected counterpart to balance their influence. It transfers to executive branch agencies whose institutional permanence gives them a structural advantage over a constantly rotating legislative branch. Critics of term limits argue, with documented support, that in states where legislative term limits have been enacted, power has in fact shifted toward governors, executive agencies, and lobbyists who outlasted the politicians they worked with. The elected body became less experienced. The unelected actors became more influential. That is not the reform advocates intended. These are real arguments. Experienced senators have produced significant legislation on complex subjects that genuinely required their accumulated knowledge. I acknowledge that directly. But I do not believe this counter-argument resolves the problem, because the question is not whether experienced senators are more capable than inexperienced ones. The question is whether a system in which the primary path to experience is also a mechanism for entrenching power and limiting democratic competition is one that a self-governing republic should accept indefinitely. In 1995, the Supreme Court decided U.S. term limits versus Thornton. 23 states had passed laws imposing term limits on their members of Congress. Arkansas was the test case. The question before the court was whether the states had the authority to add a qualification, a term limit, to the constitutional qualifications for Congress. The court ruled 5-4 that they did not. Justice Stevens, writing for the majority, held that the qualifications for Congress, age, citizenship, residency, are set exclusively by the Constitution. The states ratified a document that defined those qualifications. They cannot unilaterally add to them. Any additional qualification, including a term limit, requires amending the Constitution itself. Justice Thomas, writing in dissent for 4 justices, argued the opposite, that the Constitution is silent on whether states may impose additional qualifications, and that the 10th Amendment reserves to the states all powers not specifically delegated to the federal government or prohibited to the states. Because the Constitution does not specifically prohibit state-imposed term limits, Thomas argued the states retained that power. The majority prevailed. States cannot impose congressional term limits. 23 state laws were invalidated in a single decision. What this means practically, the only documented path to Senate term limits is a constitutional amendment under Article 5 of the Constitution. That requires 2/3 of both chambers of Congress, meaning the senators who would be term limited must vote to limit their own terms, plus ratification by 3/4 of state legislatures, or 38 states. That is a deliberately high bar. It is supposed to be. It is not impossible. The Constitution has been amended 27 times. The 17th Amendment, which changed how senators are elected from appointment by state legislatures to direct election by the people, passed in 1913 over significant opposition from senators who benefited from the existing system. That amendment happened because the public demanded it over decades. This one will require the same. Here is where I stand. As a paralegal, as an American, as someone who has spent the last 3 episodes documenting what happens when accountability mechanisms fail in the United States Congress, I support Senate term limits. I believe the Constitution should be amended to establish them, and I want to tell you exactly why, not as a partisan argument, but as a structural one. The Senate was designed for deliberation. Madison was right about that. 6-year terms, staggered classes, a smaller chamber, all of it serves the purpose of giving the Senate the stability and thoughtfulness that the House, with its 2-year terms, cannot always provide. But deliberation does not require the same senator to serve for 50 years. The institutional stability Madison described is a property of the Senate as a body, not a justification for individual lifetime careers in a body whose membership the public is supposed to control. The incumbency data is clear. The re-election rates are clear. The fundraising advantages are clear. The seniority feedback loop is clear. Elections have not corrected the structural problem, and there is no documented reason to believe they will begin doing so without a structural change. The counter-argument about expertise and power shifting to unelected actors is real, and I take it seriously. But it is also an argument that can be addressed in the design of the term limit itself. A limit of 2 terms, 12 years, gives a senator enough time to develop genuine expertise, to build meaningful relationships, and to master complex policy domains. It is not a one-and-done revolving door. It is a career with a defined conclusion that forces renewal and prevents entrenchment. 2 terms, 12 years, accountable throughout, done. The 17th Amendment changed how senators are selected because the existing system had failed democratic accountability. Senators were being appointed by state legislatures that were sometimes corrupt and often unresponsive to the public. The amendment passed because citizens demanded accountability over decades. The current system, in which structural incumbency advantages make most Senate seats effectively permanent for whoever holds them, is a different failure of the same principle. The mechanism is elections. The reality is entrenchment, and the fix is the same kind it has always been, a constitutional amendment that puts the structure of the institution in line with the democratic accountability the Republic requires. The documents are public, the path is documented, and knowing that the path exists, knowing exactly what Article 5 requires, and what the 17th Amendment showed is possible, is exactly what I mean when I say the documents are in the description. This is Words with Wentz. Know your rights.
Let the signal cut through the noise. Reading between the lines. Every story leaves a trace, unlocking time and space, finding truth with Wentz.